think you can probably move on a couple of slides, Jen, please. Yep, so today we are looking at NEC 4. So we're just going to look at an introduction to the NEC contracts. Very quickly, we're going to look at the new contracts introduced with NEC 4. Then we're going to focus on the engineering and construction contract, stroke subcontract, which is probably the one you are typically using, and look at the key changes. So particularly around money, always important, disputes, the options clauses. We'll cover the amendments since it was introduced, and there's also quite a lot of slides regarding the procedures to be followed for each of these, which we probably won't get around to dealing with. So I'll roughly be covering the procedures when we look at the topics. So the procedures in terms of the slides are just an extra for you to peruse at your leisure if you would like to. So just note when I'm talking about contractors, that includes subcontractors in a subcontract. But note, as regards timescales, we're talking about contracts. The subcontract timescales might be slightly different, so just be aware of that. So if we can have the next slide, please. So we're just kind of in terms of NEC. I mean, it's a relatively recent contract. It was introduced in the 1990s, contrast with JCT, which predates, I think, the First World War. But, you know, it's used extensively throughout the world. Next slide, please. And every now and again, they bring out a new contract. So the first one was in 1993. Oh, somebody's just said that I'm on mute. Can anybody hear me?
I can hear you, Sarah.
Right. Kevin can hear me. Thanks, Kevin. I'm going to keep going and assume that it's not my IT problem. Excellent. Thank you.
If anybody is having problems hearing Sarah, then I'm sure that the recording that I'm doing, that will be recording with volume. So I'll upload that to YouTube. So worst case scenario, you can watch it back on the channel.
So NEC 2, 1995, 3, 2005, and you'll see from each of those, the final point for each of those, it refers to new contracts that are introduced. So every time they bring out a new version, not only do they update the existing contracts, but they bring out a new contract or two. So with NEC 4, it was brought out in 2017, amended January 2019, and there have been a couple of amendments since then. The two new contracts they brought out were the DBO, the Design, Build and Operate, come to in a minute, and also the Alliance contract. So again, we'll come to that in a minute. So if we can have the next slide, please, Jen. So first of all, in terms of the terminology, now I would imagine that most of you will be working on NEC 4 now, or at least starting to work on it. So hopefully you're getting used to this new terminology. So in NEC 3, we had the employer. The employer is now called the client, which I think is more sort of self-explanatory. In NEC 3, we had the works information, which when I first started looking at NEC, I found really confusing. Now it's been changed to the scope, and we all know what that means. It's gender neutral. NEC 3 introduced as one of its changes a risk register. The title caused a lot of issues because people thought that it was setting out what the risks were, whereas it wasn't. It was just registering what the risks were, not, did I say what the, not who bore the risk of those risks. So it's now been changed to the EWN register, the early warning notice register, but basically the aim of it is to list risks. So for example, weather will generally be a risk under a construction project. Just because it's in the register doesn't mean that a particular party bears the risk of the weather. You need to look at the contract to say, to determine who bears the risk. And the register should not be used to reallocate risks. If you try to do that, so I've seen contractors and subcontractors try to do this when they're negotiating the contract, you typically will end up with a conflict in your contract where the register might allocate the risk to one party, the contract itself allocate it to another. So just be really careful about that. And finally here, there's a requirement for the project manager, the PM, to issue this early warning register within 1 week of the starting date. And I think that was because quite often under NEC 3, the risk register was never actually started. So this is basically to ensure that it gets started and therefore hopefully is kept up to date. So if we can have the next slide, please, Jen. Okay, so new contract, the DBO, design, build and operate. It is what it says it is. Just going to skim this because I don't think it will be massively used. And that's because it's got the operate element in. So I suspect it'll be a design and build contract and then operate for, I don't know, probably 15, 25 years, that kind of thing. So as it says in the second bullet point, it's a combination of our ECC, engineering and construction contract, which is what we use for a build contract, and there is a design element for it as well, and the TSC, the term service contract, which is basically a maintenance contract over a certain period. But where I think it is useful for those engaging in works under an engineering and construction contract or a subcontract is that reasonable skill and care is a standard clause in this contract. So my logic is, from a contractor subcontractor perspective, if it is a standard clause here, then logically it should be a standard clause in the ECC if there is a design element. And if you're familiar with the ECC, it's an optional clause, X15. So what I'm saying is if there's any element of design, that option should apply so that your standard of care for design is reasonable skill and care. It is only an option in case design isn't part of the contract. So if you've not got design, you don't need X15. If you have, you do need it. Simple as that. It's not negotiable. Also, it contains PII, professional indemnity insurance requirements, which goes hand in hand with the design issue, and also copyright, again, hand in hand with design. So if we can move on to the next slide, please. So the next new contract is the alliance contract. There's a lot of text there. All I'm going to say about it is, again, I think this is going to be for really large scale projects. So probably less likely to be used than the DBO that we've just looked at. We saw, not with NEC, but generally these contracts starting to be talked about more before the global recession in kind of 2008, 2009. And then they seem to kind of lose momentum. But basically, the alliance contract is one where you have one contract. It's signed by all the key parties. So obviously the client, the key consultants, the key contractor, the contractor and the key subcontractors, probably some of the key suppliers. You have one budget, very little opportunity for compensation events and extras. a single insurance policy, so a really different type of contract to what we have now generally. And very much a collaborative contract, so it'll be interesting to see how well that's used and when it is used. For the reasons that I've stated, I don't think it will be used on kind of your standard value contracts. So if we can move on to the next slide, please, Jen. Okay, so kind of moving on to the engineering and construction contract and how NEC4 is structured. So the first thing I want to refer to, because I talk a lot about the guidance notes, because I think they're helpful. So for NEC3, we had the guidance notes, 158 pages. NEC4, we now have the user guide in 4 volumes. So as you can see, the volumes take you through the life of the contract. 1 is procurement, 2, preparing the contract, 3, selecting a supplier, and 4, managing the contract. So Volume 4 is the volume that you want for interpreting the clauses. I think the others all speak for themselves. But in total, we now have a lot more pages of explanation than even the original guidance notes. But useful. And also there are some quite useful precedents in there for forms, etc. So if we can move on to the next slide, please, Jen. Okay, so on to the changes themselves. So this first one is clause 16, and it's about cost savings to the project itself. So my first query is, will this be used? The answer to that, or the feedback I've had, is that from a civil engineering perspective, probably not. I think mechanical and electrical possibly. So it's basically where the contractor can propose changes to its scope, which would result in a reduction in the cost, and the parties share those cost savings. So if you're under options A or B, are fixed price contracts, the savings are shared in accordance with what it says in the contract data. We'll come back to that. If you're on option C and D, the pain gain contract, the target contract, then how it's adjusted is via the target mechanism. So a good idea, but there is nothing to stop parties implementing this under an NEC3 if they wish to. And also, at the end of the day, it's up to the parties to agree it. I suspect it won't be well used. And I mean, certainly in the last however many years since NEC4 has been ongoing, I've not seen it be used, albeit that, of course, for the first few years, nobody was really using NEC4. They were still using NEC3. So I said I'd come back to how options A and B work. Well, in the contract data part 1, there is now a section where the parties have to complete how any savings will be shared. So the default is 50-50. So contractors, subcontractors, if you think this might apply to you, you need to consider possibly adjusting that saving to make sure you maybe get more than 50% if you think that's reasonable. How it works very quickly, and as I said, the procedures are set out in more detail later on in the slides, but we won't get a chance to look at them. Contractor makes the proposal, PM either, as we're used to with NEC, accepts, rejects, or requests a quote for a proposed instruction, and it all progresses from there and is either accepted or rejected as a CE. None of the default measures apply, so contractor can't say, oh, well, I proposed the changes, PM didn't respond, and therefore they're deemed accepted. It needs to be expressly accepted by the PM. So if we can move on to the next slide, please. So the next one, very, very similar, but this is contractor's proposal for cost savings to the lifetime cost of the project. And actually, this is the one where the M&E people tell me, that they might be able to find savings. A piece of kit possibly costs more, but will last longer and therefore result in a saving to the lifetime cost, or will be able to be operated more efficiently and therefore produce savings. So whereas the previous one for just costs of the project was a standard clause, this is in X21, so it's an optional clause. It may not be part of your contract. If it isn't included, it won't be. So my queries here, will it be used? Same as above. Will it work? Well, how this works, because it's not dealt with as a CE, it's basically that the contractor proposes the savings and then the parties have to agree, A, what that saving will be, what the figure will be, and B, how they will share those savings. Now, it might be possible that all of that can be agreed, but I think that sort of puts hurdles in the way of it being agreed. I'd be interested, in the comments section if anyone has come across these, and particularly if they've worked successfully. So next slide, please. Okay, so the next change that we have is at clause 50.9. So this is finalising the defined cost. So it's for options C, D, E and F only. So it doesn't apply to your fixed prices A and B, which, to be fair, are the most commonly used. So it's basically, I think, only going to be used in projects of a fairly long duration. And what happens is contractor finishes a part of the work, and to try and get the defined costs agreed for that part of the work so that they're set in stone, can't then be reduced later on, etc. It approaches the PM to get agreement to the finalisation of that defined cost. Fourth bullet point down, in terms of the process, PM has 13 weeks to respond to that, and that's why I think it's going to be long-term projects, not shorter term. Once they've been agreed, you can only change the defined cost by way of dispute resolution, so essentially adjudication. So again, as I've said, I think this will be limited to long-term projects, and of course, it's got to be on one of the options C, D, E or F. So if we can have the next slide, please. So this is the most major change, in my view, to NEC4. Whilst the other clauses that we've looked at so far, they're useful. None of them are, what you would call critical clauses. They don't substantially change any risks under the contract, etc. So this is the one that everybody needs to be aware of. So that's client and contractor, but also contractor and subcontractor in a subcontract. It's very similar to what we have in JCT, albeit that lots of people aren't aware of it in JCT, so that's not helpful when explaining it in a webinar. But it's basically to finalise a final account. So of course, up to NEC3, we haven't had any form of final account in the NEC contract. It seemed a bit odd at first when we're used to having one in JCT, but I think we all got used to it, to be frank. And it's never been a problem in my experience, but now we have one. I have no problem with that per se, but if you look at clause 53, what it contains is a mechanism to finalise costs and basically either ensure that parties action a dispute within timescales, and if they don't, it provides that the account is final and the party who didn't prepare it, who may not agree with it, is deemed to have accepted it unless they comply with the timescales to object. So that's my concern. That's the bit that I think is dangerous. So very quickly how the process works. So it's at the end of your defects period, so usually 12 months. So you have the defects period, and hopefully project manager issues the defects certificate. Ignore the bit in brackets in that third bullet point. So once you've had the defect certificate, the project manager issues a final assessment of the contractor's account. And it's got to be issued within 4 weeks of the defect certificate. It's different with termination. With termination, it's 13 weeks of the termination certificate. Then it obviously is sent to the contractor. If the project manager doesn't issue it within that timescale, then the contractor can issue it. So if we can move on to the next slide, please, Jen, because it becomes conclusive. So this is 53.3, as regards the one that has been issued, unless the other party, the party receiving it, basically refers it to some form of dispute resolution within 3 to 4 weeks. So basically you've got to refer it to senior reps or adjudication within 4 weeks of receiving that final assessment. And once the senior reps have dealt with it, it's then got to be referred to adjudication within 3 weeks of the senior reps agreement stroke lack of agreement. And then, of course, it's got to be referred to the tribunal, so the court or arbitration, within 4 weeks of the adjudicator's award. So this is my concern, that parties don't do that and they are deemed to have accepted whatever has been imposed upon them. In particular, I think it's a risk because from a practical perspective, for both parties, it's only issued at the end of the defects period once the defects certificate has been issued. In lots of cases, things have moved on there, both as regards the PM, but also regards the contractors' personnel. People have moved on to new projects. They're not thinking about final accounts, and that's where I think it's risky. So from a subcontractor perspective, I'm thinking, I don't know, they get their defect certificate and think, great, all the defects have been resolved. They get the final assessment and think, okay, my final tranche of retention is coming, happy days. And they don't think, but I don't agree with some of this final assessment. For example, I don't agree with the quantification of that compensation event. We're still pursuing that on possibly several compensation events, and may not think, right, well, we need to refer this, we need to get onto this and refer it to the senior reps or adjudication within 4 weeks. So I suppose that's why you're here at this webinar. And I think what you need to be doing with your NEC4 projects is thinking probably kind of, I don't know, two-thirds of the way into your defects period, whether this could be going to a dispute or not, and actually starting to think about preparing for a dispute if needed, because particularly if it's a large dispute, even if you refer it to the senior reps, so you've got 4 weeks to do that, and assuming they don't reach an agreement, you've got another 3 weeks to adjudicate. That gives you 7 weeks to prep your adjudication. That's not a huge amount for a big value. a big adjudication in terms of issues or a large value adjudication. So I just think contractors, subcontractors, you need to be diarising, as I say, kind of 2/3 into your defects period, maybe 3/4, just to sort of think, right, where is this going? Do we need to start preparing, or at least getting some legal advice, or possibly reaching an agreement to extend these periods? So if we can move on to the next slide. Yeah, so that sort of goes against what I've just said, that the guidance notes say that very little should need to be done to close the account. It sort of depends. If all the compensation events have been agreed, that's probably correct, but not necessarily. If we can move on to the next slide, please, Jen. Okay, so interim applications, I think this is what you would call a small but significant change in that the cause is stated there, but now in your interim payment applications, the contractor must submit these. The project manager has no obligation to submit any kind of payment certificate unless it has received an interim payment application from the party claiming money. So please remember to submit those. It says there, why wouldn't the contractor stroke subcontractor submit an interim payment application? Well, possibly they might forget, and of course be careful to submit it within the right timescales, because in order to bring a smash and grab adjudication, you must be able to show that your IPA has been submitted within the correct timescales. Next slide, please. Couple of new compensation events. Please don't get too excited about them because they're not significant. The first one, 60.120, contractor gets paid for its cost of preparing a quote. So that's always going to be fairly limited in terms of in monetary terms. So the cost of preparing a quote where a proposed instruction has been requested and the PM doesn't accept it. So again, proposed instructions used in a fairly limited way. I've seen them, and when they're used, they tend to be used extensively. But yeah, on most projects, they don't seem to be used. But no, that's the only area that they apply to. And then the other one is 21. Which provides that you can include new compensation events in the contract data part 1. I'm not keen on that because generally we've got used to including them in the Z clauses. And it just means, from my perspective, when I'm reviewing a contract, it means that I've got to look in 2 places rather than 1. And I like things to be kept simple and straightforward. So, yeah, if we can move on to the next slide, please. Okay, so looking at the schedule of cost components and the changes. So this is just a summary of the schedule of cost components. I think we'll just move on. Yeah, I think we'll just move on to the next slide. Lovely. So in terms of the changes, so for options C, D and E, C and D target cost contracts and option E cost reimbursable. We now only have one schedule, which is the schedule of cost components. The shorter schedule is not applicable. Not a huge change because it generally wasn't used anyway for C, D and E, or certainly not in my experience. Another change, so where we've got the removed bullet point, the second one, which is a drafting note, for the working areas overhead and the people overhead. So these are both quantifying the charges costs. So charges are the sort of miscellaneous fees payable to third parties, costs of electricity, costs of water. So I would say sort of miscellaneous costs, and I wouldn't expect them to be huge, huge amounts in terms of the sum to be paid. Under NEC 3, quite a substantial amount of the costs claimable under charges were dealt with as a percentage of the people costs, so the cost of people. That's now been changed. Now, I think that's a retrograde step because I like percentages, particularly for small value items, as here in the charges, whereas now you've got to quantify things. So, for example, the charges include, as we've said, electricity, etc. You're now going to have to quantify that as regards claims for them, which just feels a bit difficult, a bit cumbersome, and not very cost effective. Also, the design overhead has been removed, and it's now included as an addition to the rates for the designer. And also we've got the subcontractor fee has been removed from the contract data part 1, and we'll see why, I think, in the next slide, please, which I think is what has been added. Yes. So what's been added, there's a subcontractor section. This is good, I think, in terms of making the contract more efficient. So the defined cost, so DC, is simply the definition of defined cost, which is a defined term in the contract, now just says the costs paid under the schedule of cost components. Rather than under NEC 3, where it said that, but then included subcontractor costs as well. So basically, it's just moved it. It makes it more efficient because you now have a full checklist of items that are claimable in the schedule of cost components, rather than having to look at the defined cost, which referred to subcontracting, as well as the schedule of cost components. The next change only applies to options A and B, so our fixed price contracts, where we now have people rates. So bear in mind, we will only be looking at the schedule of cost components, or more accurately, the shorter schedule, when we're dealing with A and B. When we're talking about compensation events, so it has fairly limited use. So my view is that having rates for people rather than having to provide a specific costing for individuals is really efficient and much better, particularly when it just applies to the costing of compensation events. It's not how the works are generally costed, because of course that's done under a fixed fee. So I think that's good. Bear in mind, though, my caveat to that is that where you have a time of high inflation, as we have seen recently, rates don't necessarily work commercially for a contractor or subcontractor, particularly on a contract that's of long duration, because you might have, a rate for a particular person at the start of a project, but by several years later, that may not be a particularly good rate because inflation will have eroded it. And the final point, the final bullet point, is that the schedule of cost components has been added to the professional services contract, PSC, the term service, TSC, and it's also covered in the subcontracts, the sub-SC. So next slide, please. Okay, so dispute resolution. I think these are to note only. So this one applies to W2, which is the dispute resolution form that you will mainly be using. So the form where the Housing Grants Act applies. So that's it, projects in England and Wales. Ditto Scotland, unless they are part of the excluded works, which I won't go into, but just be aware that just because you're doing work in England does not necessarily mean you're covered by the Housing Grants Act. So for W2, we have an escalation process, and actually I've already referred to it in the context of the final account, the final assessment, and that's the senior representatives. So if we can move on to the next slide. So they meet within 4 weeks of an escalation. So who are the senior reps? Well, they will typically be a director or 2 directors from each business. So they're high level. Typically, I think you would want people who are not personally involved in the project. So you've got somebody who has a bit of distance from the project and can look at it pragmatically, commercially, rather, than from an emotional perspective. So the senior representatives, when you are negotiating the contract, their names are inserted into the contract data. So the client's names go into contract data part 1, contractors in contract data part 2, and ditto as regards the subcontract. So when you're negotiating, you need to think about who goes in from your perspective, but also who has gone in or goes in from the other party's perspective, because you want somebody sufficiently senior that they are able to effectively strike a deal, come to a compromise. And as I've said, somebody hopefully who hasn't been involved in the project, so they can take a dispassionate view of matters. It's a 4-week process. So you have 1 week for submissions. So basically you refer the matter to the senior reps. Within a week, both parties make the submissions. And then there are 3 weeks for the senior reps to discuss, possibly do joint investigations. Generally, it's done individually, and then to sort of get together and reach a decision. Basically, it is a chance for the parties to try to reach a resolution. It's not really like an adjudication process where, each party, each senior rep goes away and, makes a decision. It's basically for them to reach an agreement on things. And it is possible for them to reach agreement on some points. So, for example, they could reach an agreement on, that a particular CE is a CE, but possibly not as to the consequences, i.e. as to the time and money. So they need to carefully consider what the agreement is, if any form of agreement is reached. So I have used this, I think, at least once, and no agreements whatsoever were reached, and we ended up in adjudication, but there was no appetite to reach an agreement. The other thing is that behind the scenes, both parties had lawyers engaged, and that may or may not become the norm. So if we can move on to the next slide, please. Yeah, so option W3. I'm going to skim through this because generally it is for use where the Housing Grants Act doesn't apply. So it's a new option, it's W3, and it's a dispute avoidance board. Another reason I'm skimming it is that I think it will only be used on pretty large projects. And you probably will recognise this because we do have them in other projects. So you have a dispute avoidance board. So typically it would be 3 individuals. So usually there would be 3 people not involved with either business. So they will be independent to the project, but they will be engaged from the outset and they'll be involved in what is going on. So third bullet point, they are there to help the parties resolve a dispute. So they don't make a determination, they make a recommendation. It is non-binding, so the parties can accept or reject it. If they accept it, then it results in a change to the contract and it needs to be recorded. So the next slide. The reason that I don't think it'll be used very much is that typically it would involve 3 members. They've got to act impartially. They're paid in equal shares. But as I've said, they're involved from the outset. So, you know, I don't know, you'd probably be paying maybe £200-300 an hour, possibly more per member. The idea is that they're involved through the project. It's quite a costly way of getting a recommendation, which ultimately one or the other party may not accept. So, you know, it may work and it may, you know, avoid the expense of an adjudication, but I think, you know, it may not. So it's sort of a bit of a gamble from that perspective. So, you know, we'll see how well it gets used and how it is used. But I think at the moment, probably we'll be sticking to the senior reps and seeing more how that works than the dispute avoidance board. Next slide, please. Okay, so if we can move on to the next slide. Right, very quickly, option X8 deals with undertakings to clients. That's basically collateral warranties. So not going to go into detail here. Excuse me. But it's just requirements as to what collateral warranties, when they're to be provided. Doesn't actually say what happens if you don't provide it, but note it's a breach of contract, so losses can be claimed. And you might find that there are Z clauses stating that there is a penalty if you don't provide them on time, which is, you know, pretty much market standard at the moment. Next slide, please. So option X9, transfer of rights. So this is basically copyright clause. So contains copyright clauses and also requires contractor to ensure that it has subcontractors copyright also. Next slide, please. X10 deals with BIM. I'm not going to go through that. The slides there that you can look at if you want to. Option X11, termination at will by the client. So this is a clause you do not really want including. Having said that, it is already in NEC 3 as a standard clause, so it's in the core clauses. It's just been hived out and put in as an optional clause. So it's basically where the client wants to terminate for no particular reason. The cost consequences are that you will get paid the fee percentage as well as other costs. You'll get paid the fee percentage of the works you are prevented from completing. So, you know, generally speaking, it's not a huge issue if this clause is included, as long as you understand what the impact is, providing the cost consequences aren't changed. And what you tend to see is that the cost consequences are changed in the Z clauses to remove that fee percentage element. Next slide, please. Yep, multi-party collaboration X12. So again, partnering, that's a new provision. So sorry, that's what used to be called provision partnering. They've just changed the name. Next slide, please. X15 contractors design. I've referred to this already. So it's always it was in NEC 3. But it now includes PII, professional indemnity insurance requirement. That's often still changed by way of the Z clauses, as are copyright and The other optional clause that we looked at about collateral warranties, and also it now works in conjunction with the core insurance provisions at clauses 84 and 85. Next slide, please. X16 retention bonds. So this is a new provision, and actually, I think retention bonds seem to have gone out of fashion now. There seemed to be a sort of trend for them a few years ago. So yeah, it just allows for a bond rather than retention. Next slide, please. X22, you might have come across this already because this is two-stage contracting, which is, in my experience, gaining some traction. So basically, stage one is that early contractor involvement to do the things that you might otherwise do under, say, a letter of intent. So possibly early ordering, which has become a trend since we've had high inflation, but also doing ground site investigations, things like that, but also pricing the work. Now, as you might expect, particularly because it's early stage involvement and of course it's NEC, the contract keeps a very tight rein on the contract, on the pricing. So the contractor is required to provide cost forecast, detailed cost forecasts on a weekly basis for the PM to accept or reject. It's that tight. As it says there, time can be used to get consents, approvals, finalising cost, finalising design, etc. Also, from the client's perspective, allowing the client to interrogate cost, interrogate design. Next slide, please. And the stage two is your engineering and construction contract when the scope has been agreed and the price has been agreed. But note that before you enter into the stage two, both parties have the option. It's basically up to each party. If the scope and the price and I guess the timescales can all be agreed, they proceed to stage two, the engineering and construction contract. If they don't, then client's free to go out to tender and get another party to carry out the works. Contractor's free to say, not interested in doing this work, thank you, we want to walk away. So I think that's good from the contractor's perspective. Next slide, please. Some programming changes. So clause 31.3. This only applies to the first programme that the contractor produces for acceptance. And there's a default mechanism. So the new provision is basically that if the project manager fails to accept or reject it within the contract timescales, then the contractor provides a default notice, third bullet point, and the project manager has 1 week to respond. And if the project manager still doesn't respond within that 1 week, then they are deemed to have accepted it. Now, it doesn't apply if the programme is sewn into the contract, which is my recommendation. And as I say, it only applies to that first programme. What I have seen, so no, just ignore that. So that's everything. If we move on to the next slide. Right, some small changes to liabilities insurance, which I'll leave you to sort of read later. If we can move to the next slide. Yep, so second bullet point, we've covered the first. Second bullet point, Corrupt acts at clause 18 replaces illegal and impossible requirements. At 28, we now have an assignment. So you've got to notify if you are going to assign, so i.e. transfer the benefit of the contract. You've got to notify the other party. And a new clause at 29, disclosure, which, as it says there, is basically a confidentiality clause. Finally, acceleration clause 36.1. We've already, NEC has an acceleration clause in. Again, in my experience, not well used, but this new clause states that the contractor can propose acceleration. Whereas NEC3 only allows the PM to do that. So, of course, acceleration is, the contractor has a duty to mitigate its own delays and a general duty to mitigate delay. Acceleration is where the contractor is going to bring on extra resources to try and catch up and reduce delay. It's not a compensation event, but it's acceleration. So you need, as a contractor or subcontract, you need the other parties, so the project manager or the contractor's agreement to A, accelerate, and B, the costs of it. Okay, next slide, please. Yeah, I think we can skim over that, Jen, and move to the next slide. Yeah, so the January amendments, they're not significant. So I'm just going to leave those. If we can move on to the next one, which are the October amendments. Option X 7.1. This provides, and we've got a similar change in the new JCT 2024 provisions, which provides that if you terminate, the liability for delay damages ends, and liability for general damages starts. So your delay damages are your liquidated damages. So they end if the contract is terminated, and you go on to having to compensate with general damages instead. And a small change to the project bank account. Next slide, which I think should be the 2023 amendments. And again, yeah, they're all relatively minor changes. So I'll just leave them for you to review yourselves. Right, so we now have a lot of slides that are headed procedures. So I'm not going to go through those. So if you can just skim through all of those, Jen, please. They all have procedures at the start. Yeah. So as we're skimming through them, you'll see they're all topics we've covered, and it's just a slightly more detailed explanation as to those procedures. Just FYI, basically, it would take a lot longer to go through all of those. So yeah, which brings us to the conclusion, actually 4 minutes in advance, which is good for me. So, I mean, generally, it was thought back in 2016 that the transition should be quite simple, although, this is, a good hour's webinar, and there are some important things in there. As I said, partway through the webinar, none of this massively changes the risk between the parties. So that's why NEC coined the phrase, it's evolution, not revolution. NEC3 at the time was still being supported. I'm not sure that it is now. So in particular, that point that we just looked at, the 2023 change, which provided for general damages post-termination. That was to cover some case law that had been through the courts. And of course, it doesn't apply to NEC3. Parties are being encouraged to use NEC4, and certainly my experience now is I'm not seeing any new contracts on NEC3. But of course, obviously, it takes a while for the NEC3 to kind of get flushed through the system. So I think finally, don't overcomplicate. But I guess I possibly shouldn't be saying that to you, because it's generally the client who makes the changes and introduces all the Z clauses, not the contractor or the subcontractor. So I don't know whether we've got any questions, Jen. Happy to answer any if there are any.
So there's no questions that have come in just yet. If anybody does have anything that they think about afterwards, by all means, if you want to email me those over, I know that you're always happy to take questions after Sarah, so thank you. And thank you for the webinar today. As I said at the very beginning, if anybody does want a CPD certificate, please pop me over an email and I'll get that out to you as soon as possible. I will send a copy of the slides over, and that will include the link for the YouTube recording. And also in terms of next month's webinar, that will take place on the 17th of June, and that's going to be looking at risk management, so avoiding and resolving disputes. And I am also really pleased to say that as of Thursday this week, we're actually back to doing the face-to-face seminars. Now Sarah is almost fully recovered after breaking her leg. So if anybody would like to attend the face-to-face seminar next month, that will take place at the Bridge Hotel and Spa in Wetherby, and that will be on Thursday the 19th, and that's a breakfast seminar where you'll get a breakfast sandwich, some refreshments, really good chance to network and also speak to ourselves at CECA and also Sarah face-to-face, which is always really nice. I think that's it. I feel like I've rambled on a little bit there. But yeah, if there's any questions or anything, guys, then just pop me an email. And if not, I'll see you next month. Thanks, Sarah.
Thanks, Jan.